Hello, my name is Trevor Lane, and I'm a litigator here at Beresford Booth. My practice specializes in litigation, particularly with an emphasis on contract law and construction law, representing general contractors, owners, and subcontractors in the commercial, public, and residential spaces. Today, I'm going to be talking about protecting contractors' rights at the beginning of a project, particularly with regard to general contractors and subcontractors in the residential construction areas. Often, I have general contractors, subcontractors, and even homeowners calling me towards the end of a project, after a project, or sometimes years after a project, inquiring with regard to their legal rights, considering litigation, often looking for a payment that is owed. This can arise from a change order or just one party failed to pay, or there's some dispute over the work itself. I also receive a lot of calls with regard to potential construction defect claims. In all of these situations, more often than not, the news I have for the client is not great. For some reason, there wasn't a lot of forethought before the project began. There wasn't a lot of thought putting together the initial contract. And the general contractor or the subcontractor is often in a position where they don't have as many rights as they would like to in pursuing money that is owed or in defending against a construction defect claim. So today I want to talk about some things to consider before a project begins that will give you a lot more options in the event that something does go wrong halfway through, towards the end, or after the project has begun. So to start, the contract itself is key. A lot of general contractors and subcontractors rely on bids and proposals or a form contract that they receive from an attorney or that they downloaded from the internet. These contracts, bids, and proposals are often not project specific, but are something that gets reused over and over again through many different projects. A lot of times, the contractors and all parties involved in these deals don't really have a firm idea of what's actually in those contracts. They read them once years ago and they've just been signing them for multiple projects, but they don't have a lot of specific knowledge of what the contract actually says with regard to their obligations and rights. The document, in a sense, is not a living document that's relevant to the parties involved in the contract. And bids and proposals, while they provide a lot of information regarding the initial scope and price of the project, they often don't reflect change orders and they don't speak to issues that may arise later, like if there are significant changes to the project scope, or if one party is terminated, or if there is a lawsuit, who will pay for attorney's fees. So, one of the most important things to do at the beginning of a project is to have a conversation with the parties you're entering into that contract with about the project specifically. A contract, it helps if it's written. It really should be written and signed by both parties, and both parties should retain copies of that signed contract. But the contract itself need not be multiple pages or necessarily even written by a lawyer. The most important thing is that the parties have a firm understanding of the terms of the contract, and the contract is written in a way that reflects both parties' understanding of the work that's going to be done. A good written contract includes the scope of the project, what each party is going to do, the price of the contract. If there is something custom or unique about the project, that should just be written down in the whatever the written agreement is between the party. It's really important that the parties have some thought ahead of time with regard to changes and how the parties will handle those changes when they arise. Um, are changes going to be communicated via text, via phone call, in writing? Are those changes going to be accompanied with a cost? What's that cost going to be? Those are all things that really should be nailed down ahead of time. A lot of times, parties may have a small change at the beginning, a couple other changes in the middle, and they seem small, they don't seem consequential, and they don't really think about it. But towards the end, those small changes can accumulate into um, a big price increase for the general subcontractor. And if the parties never really had an understanding for how those changes were going to be paid for or what the scope of them was going to be, it can easily lead to a dispute. Another thing to consider is what if something goes wrong in the project? Maybe the working relationship breaks down, or there's a global pandemic, um, or there's an earthquake, or something that the parties cannot anticipate at the beginning of the project, but it is part of human life. There should be some consideration with regard to how the parties are going to handle termination, both for convenience and for cause. And by that, I mean there are times when it makes sense for the parties to walk away from a contract for reasons that aren't a global pandemic, but are just in the best interest of the parties. And there should be a discussion of how the parties are going to handle that. Three other things that are really important are one, attorney's fees. Attorney's fees are essential. In Washington, if there's a lawsuit on a construction project, the winning party in that lawsuit is not necessarily entitled to their attorney's fees. And it is really difficult to recover attorney's fees if it was not originally in the written contract. So that's something that should be in there. Something as simple as if the parties enter into a dispute in litigation or otherwise, the parties agree that the prevailing party shall be entitled to their attorney's fees. Anything like that would get the job done. Additionally, the parties should consider if things were to really fall south, how they're going to handle it. There are more options than litigation. There is arbitration, there is mediation, and there could be other creative solutions that the parties may rather get into than expensive litigation. Finally, the most important part of a written contract is that it remains a living document through the course of the project. If there are changes that are significant, or if the parties, for whatever reason, need to alter their course, just write those changes down and sign that as an amendment to the original contract. Those are incredibly helpful things if something goes wrong. Attorney fees. I mentioned that before that needs to be in a written contract, or the party should at least contemplate whether they want to include that in a written contract. Attorney's fees make a big difference when a contractor or subcontractor calls me and we're discussing the issues and the practical costs of moving forward through a dispute. Attorney's fees are expensive. Pursuing a change order, pursuing a contract defect claim, could be tens of thousands of dollars. Often it could cost more to litigate an issue to recover money that's owed or to recover the cost of repairs than the repairs and the work itself actually are. And if there's not an attorney's fees provision, it makes no sense to pursue litigation, and whatever money you were owed is just left on the table. Having some sort of attorney's fees provision really makes a big difference when the conflict arises. The third thing that's important that contractors should consider at the outset of a project are liens. You do have the option to file lien against the property itself under RCW 60.54. However, those liens don't always work the way contractors believe they do. There are certain circumstances where you need to and want to provide notice before the project begins of your lien rights, a contractor providing that notice both to the general contractor and to the project owner. But also, there are timing issues with regard to when you can file a lien. A lien must be filed 90 days and served 90 days within 90 days of the last time that contractor provided services or provided materials to the project. And then there are additional service notice requirements and requirements for starting a lawsuit if you do file a lien. A lot of times attorneys, assume that they have a lien right just by performing work on the project, and that lien right gives them attorney's fees, and it is a strong tool they have if something breaks down, and it can be as long as you're familiar with RCW 60.54 and you have an idea of when you need to provide notice before the project begins, what kind of notice you need to provide, and what you need to be thinking of with regard to timing if you're in a situation where you do need to file a lien. The fourth and final item I want to talk about are construction defect claims. Under RCW 64.50 in Washington, there's this construction defect claim statute that allows owners of a project to file a claim for defects for a new or remodeled property for 6 years. And that's above and beyond any warranties that a builder would provide a homeowner. So homeowners have essentially 6 years to pursue a construction defect claim. Now, that's a really powerful tool for homeowners and it can be the homeowner's best way to initiate a lawsuit against a builder or subcontractor. But in those situations, there are certain things that need to be looked at. The construction defect claim does require certain notice provisions that the builder needs to provide the homeowner before the project begins that can incredibly bolster the contractor's rights and require the homeowner to provide notice to the builder before they file the lawsuit. Those can be a little nuanced and legal and complex, and both with construction defect claims and with liens in general, it's highly recommended that you contact an attorney and review the applicable statutes and have a clear understanding of how these tools work, how these statutes work, when notice needs to be provided, and what the timing issues are there. So, with that said, the four big takeaways here are one, have a written contract, make it specific to the project itself, revisit that contract and make amendments in writing and sign when needed. Really make sure that you are contemplating your right to recover attorney's fees before the project begins. Know your lien rights and what you need to do to protect your lien rights, and know what you need to do to protect yourself in the face of a construction defect claim. If you have any questions at all or need any assistance, feel free to contact me, Trevor Lane, here at Beresford Booth, or any other litigation, real estate, business attorney here at Beresford Booth. Thank you.